Everybody. I'm Joanne Geer. I'm the Executive Director for the Westchester Biotech Project. I want to let everyone know that we are recording the session today, but we only put the presentation part on our YouTube channel. The conversation that we'll have after our presentations will not be, although if we want to quote you somewhere, we will call you and ask you for your permission. We have two great speakers today who represent different aspects of looking at the international picture. You'll be getting into that in a moment. But first I want to introduce Michael Welling, my partner, who will give you a little background about our organization and where we're headed. Michael.
Thank you, Joanne, and good morning, everyone, and thank you for joining us. You know, our new sort of greeting, I feel like, has become, I hope you and your families are safe and healthy and comfortable wherever you are. But, you know, things don't stop despite all the new challenges. And I think today is a great opportunity to discuss some of the moving parts that are behind the scenes of science and of the business side of science, some of the international impact that we're seeing and how business is being done to continue to promote science. For those of you who just were joining us and missed Joanne referencing a Wall Street Journal article talking about that Regeneron, which is right here in our backyard in Westchester, was received fast-track FDA approval to pursue some COVID-19 research overseas. And I think you know, this is something we will probably start seeing more and more as the need grows. But just a little backstory here for those of you who are joining us for the first time. Thank you. Westchester Biotech Project is a not-for-profit organization created and founded by myself and Joanne Geer, really for the sole purpose of creating a platform to foster dialogue and collaboration and further ideas, truthfully, around the world. And again, today really speaks a lot to that. While we have Westchester in our name, I stress that we are a borderless international cohort. We plant our flag here in Westchester. We like to highlight what's going on here in Westchester, but we are in no means focused only on Westchester. In fact, just the opposite. We focus our time and attention on what we call the core of the engine that drives this whole community, the researchers, the data scientists, and the engineers, folks who are at the epicenter of any good scientifically based business or research project, but oftentimes are not the ones who are receiving the support and certainly not the accolades that they often do deserve. So we sort of have focused our time and attention on trying to highlight all the great work that's being done by them. And we do this by focusing on three core areas. As you'll see here, our famous or infamous dots. As I like to say, we spend a lot of time connecting dots, but our three main sort of buckets of focus are lab to market initiatives, building the cluster initiatives, and connecting community. Everything that we do, which you can find every one of our events on our YouTube channel or referenced on our website, falls under one of these three buckets, as we believe these make up the core of the secret formula to build out this community and create a foundation for it to survive and thrive. And so should there be anything under any of these headings or any of, you can go to the next slide, or any of our other initiatives, and you'll see a number of our charrettes listed here on this screen, we encourage you to reach out to us. Jump in if you have an idea, a thought, a recommendation, a question, a criticism, we take it all. But really, our success has been built on the feedback, the response, and the contribution of all of you, and in no small part by our partners who you will hear from today as well. So this truly is a collaborative effort and one that we are tremendously proud of. That collaboration obviously would not be possible without the support of our partners, and you see on this screen here many but not all of those partners. Today you're going to hear from some of them, and we encourage all of you, if you don't know who some of these folks are, reach out. We're happy to make introductions if there's something specific, business opportunity, project opportunity, whatever it is. We love making those introductions and connections and building out our community that way. So Joanne loves putting this slide in here as she touts this sort of as part of our philosophy, and that is we always overestimate the change that will occur in the next 2 years and underestimate the change that will occur in the next 10. I will tell you that this has been something that has required us to kind of force down the throats of many of the sort of institutions and hierarchies that we've come to deal with, as many people are more interested in seeing the headline or the press release of something flashy and less concerned or willing to put in the time and energy to really build the machine for the long term. And we have really focused on the long term. That said, one of our partners, Paul Savage, I'm not sure if he's with us today, who helps chair our data science roundtable, has provided us with a comical update of this, in which he says now we are always overestimating the change that will occur in the next 2 weeks and underestimate the change that will occur in the next 10. So we've taken that to heart as we have moved forward here as well. One of the things that we love to point out is what's happening in our backyard right now from physical infrastructure development. And this here is Ardsley Park is a project that's being executed through one of our partners, Biomed Realty Trust, a Boston-based life science real estate development firm. They have seen the opportunity of investing some significant capital into this property here in Westchester and building out what now seems like even more of a significant opportunity, and that is providing lab space, wet and dry, and meeting space in the life science world outside of New York City, where obviously there are logistical challenges now, even just getting to and from some of those. So we certainly applaud their efforts in recognizing the opportunity there. So before we start today, I'm going to momentarily introduce two of our longtime friends and partners to our efforts here. Brian Hand, an attorney with Nordlicht & Hand, and Steve Chu, representing our international partnership with Montero Language Services. For any of you who were able to join us at what seems like the last time I interacted with anyone in person that wasn't my family, on February 27th at our State of the Biotech community breakfast, you would have seen Steve's partner Fritz fly in from Madrid to speak and present with us at that event. And today, Brian and Steve are going to talk about what does the world look like today in doing business internationally. I know that we are seeing lots of changes in the mergers and acquisition world, the partnership world, the language that's required in contracts and documents and insurance. And what's the only, they say change is the only constant. And so I keep saying, hey, listen, business is still being done, but it needs to be done in a way where you are accounting for the new knowns and the potential unknowns. And Steve and Brian will talk about some of those concerns, some of those issues, and I know we'll all enjoy and appreciate what they have to share. So let me turn that over to Brian. And again, thank you all for joining us.
Well, thank you, Michael. Thank you, Joanne, for the invitation to speak today, and greetings, everyone. Thanks for joining. So as Michael mentioned, I'm an attorney. I do work in the life science areas. I've been doing it for over 30 years, God help me. We practice in all aspects, from licensing to financing for startup and mid-stage companies, mergers and acquisitions, and the variety of contract work that comes up for life science companies. We work on the medical device side as well as vaccines and diagnostics. So I had initially planned my discussion today on trends in international licensing and mergers and acquisitions. Given recent events involving the COVID-19 crisis, I am also going to be spending some time talking about that, specifically from the perspective of how to deal with situations in which a party to a contract is unable to perform their obligations due to the pandemic. Finally, I'm going to close with a discussion on CEPHEUS reform and the impact on foreign investment in US life science companies. So let's get started with licensing. One big caveat for both licensing and M&A is the effect that the COVID-19 crisis has had. There's been a great deal of disruption. Transactions are not getting done or they're suspended. And it's difficult to know when activity is going to pick up again and what that's going to look like. The market trends I'm going to be discussing are based on reported industry data over the last few years. Once the corner is turned on the virus, I expect the deal market to pick up, and these trends will continue to be relevant. The trends over the last few years show that for big pharma, in-licensing of drug candidates continues to outpace out-licensing of non-core assets. International deals continue to constitute more than 25% of life science transactions. Licenses for global rights to a candidate constitute more than a quarter of all reported licenses. Hot areas for licensing have been oncology, neurology, endocrine and metabolic disorders, and genetic disorders. Gene therapies are a growth area for both international and domestic license transactions. As to the deal terms that we're seeing, there's a growing trend for greater upfront payments, much higher than what used to be common. The majority of licenses the last few years have involved preclinical drug candidates. There's also been some growth in licensing for phase 2 candidates. Licenses for phase 3 deals were in the decline. I can speculate that that's due to the scarcity of phase 3 candidates available for licensing, or substantially higher valuations in comparison to phase 2 and preclinical candidates. There's still a trend for licenses, especially early stage candidates that are licensed, to include co-development and research and development collaboration. That's especially the case for in-licensing by big pharma, who use more nimble and smaller pharma and biotech partners to do that work for them. The majority of licenses for later stage companies, later stage candidates, are more typically straight up licenses without other components, but we still see some that feature co-commercialization and supply arrangements to go along with the license. The supply arrangements typically are for raw material and active pharmaceutical ingredient. Moving on to mergers and acquisitions, drivers for the M&A market, both in international and domestic deals, remain consistent. Big companies with sparse or non-diverse pipelines, or that have top revenue drugs which are nearing patent expiration, continue to be on the lookout for acquisition candidates, be it individual drug candidates, operating units, or entire companies. Another driver is the growth of the use of innovative artificial intelligence and machine learning technologies in life science R&D and in the optimization of patient outcomes. Life science companies are going to be on the lookout for innovative big data companies to join forces with to take advantage of emerging technologies in those areas. Other M&A deal drivers that continue to drive the market include efforts by life science companies to divest non-core assets and to capitalize on their investment in those assets by selling them off. Other drivers are enthusiasm for acquiring new classes of drugs, like immuno-oncology and orphan drugs, which were particularly hot the last year or two, and unlocking synergies from acquiring complementary product portfolios and companies with synergistic visions. Overall, licensing is still a lower cost strategy than M&A by far, but M&A has the advantage of offering complete control over the asset that you're acquiring. As an example, in the past year, there's been a very large number of mega deals among international life science companies. Some examples, Joanne, you can move the slide. Some examples are Obvi and Allergen, which is pending. That's actually been delayed a bit because of the COVID crisis, but that one has a price tag of $63 billion. Some other big deals were Novartis's acquisition of the medicines company, Bayer's acquisition of Elanco Animal Health, and the Shire Novartis deal. Those were all international deals valued somewhere between 5 and 10 billion. As for the future, again, things are a little bit open-ended because of the uncertainties created by the COVID-19 crisis. That situation in and of itself will provide opportunities in both the diagnostic and vaccine market, as we're all aware. Everybody's rushing to get the key to unlock treatment and vaccine options, and there's going to be a great deal of transactional activity around that. Once the dust settles, you can expect to see the continued consolidation and acquisitions in the gene therapy market. Big Pharma is always going to be seeking out promising drug candidates to fill up its pipelines, and there's going to be a shift from products to patient outcome, and the use of artificial intelligence will be invaluable in that respect. Prevention of disease is going to have a much higher value proposition than in the past, and is going to be a focus of deal activity. I'm now going to speak a bit about the effect of the COVID-19 pandemic on the transaction world. It's a really big topic, and we don't have that much time today, so I'm going to focus the conversation on some general contract considerations. These would be applicable whether it's an international or a domestic transaction, and would also apply whether it's a license, an M&A deal, or any kind of contract that life science companies come up with in their day-to-day activity, such as materials transfer agreements, CRO agreements, and the like. Let's first talk about existing contracts and what we need to do with those. You may be in a position where you are trying to find a defense for not being able to perform under a contract. Or you may be on the receiving end and finding out that a vendor or another contract partner tells you that they are unable to perform. The first thing you're going to need to do is check the force majeure clause in your contract. That's part of the legal boilerplate that everybody tends to gloss over, other than lawyers, but it's becoming pretty important right now. Both civil law and common law jurisdictions recognize the concept of force majeure. The force majeure clauses in a contract provide an excellent opportunity for excusing non-performance by a party if the reason for non-performance was beyond the party's reasonable control. It would seem that a pandemic fits the category of being beyond someone's control, but as with all things, the devil is in the details. In some civil law countries, like China, for example, force majeure exists by statute. It doesn't even need to be in the contract. It's written into the law. However, it's very specific, and you need to check all the boxes in order for it to apply in countries like that. On the contract level, most of your contracts are going to have force majeure clauses. They're all going to be very different, and there's going to be a need to review and read them carefully. In most cases, these clauses are going to define specifically what types of events are covered and could be eligible to excuse non-performance of a contract. Those could include things like natural disasters, strikes, wars, and civil unrest. They may or may not include epidemics. Some do, some don't. So again, the first thing to do is check to see if your force majeure clause covers the situation. Second, even if it does cover epidemics, that's not the end of the inquiry. If you want to rely on it to excuse non-performance, you're going to have to show that you did in fact make efforts to perform, or that you tried to mitigate the situation. Most force majeure clauses also have a notice provision where you need to let the other party know that there's a problem, and you are going to have to comply with that. So, if you're in this situation, the best course of action is to do each of the following. First, review your contract to determine what your rights are and what the rights of the other party are. Second, review the facts and determine if the COVID-19 crisis or the events related to it, such as government-mandated shutdowns, are preventing you from performing. Third, make sure you notify the other party in a timely manner that you're unable to perform and let them know what steps you're taking to try to mitigate the situation. You'll have to prove that the pandemic was the cause of your inability to perform, that it was unforeseeable, and that you did everything possible to try to mitigate the situation. For example, when we first got word of COVID, if it was possible to start building up inventory for a supplier in anticipation of potential interruptions of their supply chain, and they failed to do so, then relying on the force majeure clause is not going to get you very far. Beyond force majeure, there are other legal defenses to non-performance of contractual obligations. These apply both in common law and in civil law countries. One of them is the doctrine of impossibility. Impossibility is a fact-based inquiry in which a party to a contract could try to argue that they should be forgiven for not performing because changed circumstances makes it impossible for them to do so. Let's consider the case of a supply contract in which one party agrees to provide a supply of API to a manufacturer of a finished product. The API supplier may not be able to deliver its requirements during the pandemic due to interruptions in its own supply chain, such as unavailability of raw materials, interruption in their transportation, illness of necessary workers, plant closures, or any other reason. They could argue that these conditions make it impossible for them to perform, and then they should not be penalized for breaching their contract. Another potential defense to a breach of contract arising from the pandemic is the doctrine of frustration of purpose. Frustration of purpose is a little bit different than impossibility. Frustration applies in situations where a party can perform its obligations, but an event occurs which is unforeseen and it undermines the very purpose for which the contract was entered into. Frustration of purpose is a very narrow remedy, and it usually would not be an effective defense unless there is a situation that was truly unforeseeable and an extreme hardship would be the result if a party was held to the contract. Let's take as an example someone that is committed to sponsor an industry event that is seasonal in nature. If people are unable to attend the event, its very purpose has been undermined, and the sponsor will seek to terminate its obligation on the basis of frustration of purpose, even though they are completely capable of making the payments due for their sponsorship, and there's a promise that the event could be held at a later date. For legal purposes, again, impossibility and frustration of purpose are recognized in both civil law and common law jurisdictions, so they have an international scope. However, not every country views them the same way. So you have to take a look, not just at the clauses in your contract, but in the governing law that applies to the contract, and then check to see how these concepts are applied under that country's law. So there's a few things to take away from this in negotiating contracts going forward, particularly in the international context. First, Your selection of governing law is critical. For those of us that practice in this area, we are well familiar with the situations involving parties to a contract from different countries, where we spend a lot of time arguing over whose law is going to govern. In most cases, we will usually settle on a neutral country's law just to get the issue out of the way. But we're going to need to be very, very careful to make sure that the laws of whatever neutral country is selected is going to produce an outcome that we expect. Second, in light of the pandemic, force majeure clauses in contracts are going to get increasing attention, and they're going to evolve. As I mentioned earlier, sometimes epidemics were included in force majeure clauses, sometimes they're not. But in the future, not only will they be included and a standard part, but there's going to be a great deal of negotiation about defining what a pandemic is, and also going into detail regarding each party's responsibilities during a given transaction and the effect it would have in terms of a party's ability to terminate or postpone performance. Every party's responsibilities in that situation will need to be spelled out to avoid uncertainties. Third, there's going to be a great deal of litigation dealing with the applicability and scope of impossibility and frustration of purpose as defenses to a breach of contract. This is going to be an evolving area of law in each jurisdiction, and how those doctrines apply in each place is going to be open for discussion and will be evolving regularly. As a final point on this topic, going forward and always, the legal staff and the commercial staff and businesses need to work together. You need to make sure that the aims of your businesses are achieved at the same time that proper precautions are being taken. The final subject I'm going to discuss today is in CEPHEUS reform. Some of you may be familiar with it, but for those of you who are not, CEPHEUS is the Committee on Foreign Investment in the United States. It's composed of several overlapping departments of the executive branch of the United States government, including Treasury and Commerce. It exists as an oversight group for foreign investments in U.S. companies. CEPHEUS has always been there, and there's always been situations where it has gotten involved in some large transactions. But the Foreign Investment Risk Review Modernization Act, and that's a mouthful, greatly expanded the scope of transactions that CEPHEUS can review and the industry sectors that are subject to review. The life science industry is specifically affected by those changes, which is the reason why I'd like to talk about it a bit. Traditionally, a CEPHEUS review could be triggered if a foreign person or a person acting for a foreign government acquired control over a U.S. business. Under the new regime, the scope of CEPHEUS review has been substantially broadened, and non-controlling investments in critical technology are also subject to review. The importance of this is that a failure to report a pending transaction to CEPHEUS and obtaining clearance for the transaction could result in a government inquiry into your transaction, which might end up causing a completed transaction to be unwound. That has happened a couple of times in the past, and it's going to be more of a situation in the future going forward. One of the focuses, and an important focus of the reform, is on what is now considered to be a critical technology. To some extent, this is still evolving, but for purposes of the life sciences community, areas such as biotechnology and neurology, nanobiology and synthetic biology, genomic and genetic engineering, nuclear materials, and artificial intelligence and machine learning are expected to be designated as critical technologies. Beyond that, CEPHEUS review now also applies to investments in US businesses that use sensitive personal data to target or tailor products or services to sensitive populations, such as the military, or that collect or maintain sensitive personal data on more than 1 million people. Sensitive personal data includes data that deals with things such as physical, mental, and psychological health, long-term care, life insurance, and genetic sequencing. Under CEPHEUS, there are two types of filings, mandatory and voluntary. Mandatory filings are required for foreign investments in which a foreign person would end up owning more than 25% of a business, and in which that foreign person is owned by a foreign government in an amount of 49% or more. The interest of a foreign government in this foreign person could be obtained through a state-owned company, a sovereign wealth fund, a state-run development corporation, or any other foreign government entity. Now, there are a few limited exceptions for certain investors in the United Kingdom, Australia, and Canada. It's important to note, however, that the exception for investors from those countries does not apply to all. Voluntary filings should be considered for non-controlling investments, that means less than 25%, in companies in US businesses that produce, design, test, manufacture, fabricate, or develop critical technology in or primarily for use in one of 27 key industries involved with critical technology. And again, as I mentioned earlier, biotech and genetics are expected to be in the category of those 27 key industries. Whether or not you will need to make a voluntary filing has to be determined in each given situation where there's a non-controlling investment, and it's going to depend on whether there is some national security nexus to the investment and to the business. Companies that are involved in these transactions with foreign investors are going to need to look at them carefully and determine whether they should make a voluntary filing, even if not all of the boxes are checked for a mandatory filing. Now, there is a downside to doing a voluntary filing. One of them is the delay this is going to cause for your transaction. The process from when you submit the application until it's reviewed and you obtain clearance could be over 120 days. The determination of whether a transaction will be permitted is going to wind its way through the various agencies that make up CEPHEUS and could escalate all the way up to the president for a final decision. The advantage of doing a voluntary filing is that if at the end of the review your transaction is cleared, that becomes a safe harbor and ensures that there will be no further government inquiries into their transaction, and you have no worries of your transaction being unwound after it has been completed. You should note, however, that about 30% of voluntary filings will end up with no official clearance, but no adverse government action either. I know that's not much use, but generally speaking, that's a pretty good sign that the government is not interested in what you're doing. Again, if you choose not to do a voluntary filing where there is a potential national security nexus for your transaction, you run the risk of having CEPHEUS initiate a review and the transaction being unwound. By voluntarily filing, you are able to control the narrative. And whether you have a national security nexus for the transaction could be obvious depending on who your investor is and what your industry is, or it may require further digging by professionals who are working in this area. CEPHEUS is going to continue to evolve as guidelines are being developed for further defining the technologies that are covered by it, along with enforcement guidelines. CEPHEUS obviously applies more directly in an investment or purchase of a business context, but licensing transactions are also implicated if critical technology is being out-licensed to a foreign party, or a foreign party gains access to critical technology through things like R&D collaborations. So, CEPHEUS should be treated as a gating issue where there is a transaction between a US company and a foreign partner. Due diligence needs to be conducted to determine if your foreign partner is ultimately controlled by a foreign government actor. It's going to be necessary to drill down on documents during due diligence, and Steve in a little bit is going to talk about getting translations done for those documents. The need for that is heightened if you're going to have to file these documents and other agreements with CEPHEUS in the context of a review. From a contractual standpoint, representations and warranties that are relevant to CEPHEUS should become a standard part of all of your contracts with foreign partners. And if either a mandatory or a voluntary filing is needed, that should be factored into the time it takes for you to get to closing and for the conditions to closing that you put into your contracts. That brings me to the end of the segment. I'm going to turn it back over to Michael, and everyone, thank you for listening and tuning in today.
Well, there's applause. Hi, everyone. Michael, do you want to say anything right now? I was going to head on to the next.
No, only that, not only was that fascinating, but he's doing it on like 30 minutes worth of sleep. So it's even that much more impressive.
4 hours, 4 hours.
4 hours, yeah, but who's counting, huh?
Yes.
Well, hello, everyone. I know we've had a few people join us. I'm Joanne Geer. I'm the Executive Director of the Westchester Biotech Project. That's Michael Welling. Wave, Michael, my partner in crime. This session is being recorded. What we're going to do is go on to our next speaker, who's Steve Chu, who's going to speak about language issues in all of the matters we've been discussing. And then afterward, I'm actually going to call on people on the call and invite you to introduce yourself, talk about your work, and make any questions or comments at that time. We'll be able to have a really nice, juicy round table. So I am going to, Steve, I'm going to make you the presenter now.
Thank you, Joanne.
Sure. We want to start, well, let me get you settled in, and then you can introduce yourself. Really happy to see all the different people who have arrived today. This is a nice group. I know there's some folks here that we've met before, but I see we have a bunch of new people, so welcome everyone. Okay, here it comes, Steve. You're going to get a little pop-up. There you go.
Can everyone see my screen?
Beautiful. You just make your slides full screen and we'll be all set.
Perfect. Okay, let me get started. Good afternoon, everyone. You saw in the email invitations that the speaker today is listed as Fritz Handtke. So by way of introduction, I am not Fritz. I think you all have figured that out already. I'm here representing Montero Translation Services. Montero is a language service provider. So I often get asked this question, well, what the heck is a language service provider? In short, we are a translation company. Montero is headquartered in Spain, where Fritz is based. I'm actually based right here in Westchester County in White Plains. Montero has over 50 in-house multidisciplinary linguists and translators, many of whom have expertise in legal and IP translations. In fact, Montero is also recognized as one of the top translation agencies in the area of legal translation specialties. And we have done a lot of work for law firms, IP law firms specifically across Europe and the United States. And here are some of the areas of our expertise when it comes to the verticals. So healthcare, biotech, and we'll be speaking about IP translation issues in those particular verticals today. So echoing what Brian said earlier, there is tremendous of international licensing deals and M&A deals. Brian cited some 25% of the deals in pharma licensing deals, and 20% in big pharma licensing deals have global rights. And these cross-border and international licensing and M&A deals obviously have a language component, meaning that they may require translation. The obvious things being the agreements themselves, but more importantly, leading up to the filing, there is going to be a tremendous amount of due diligence that needs to be done, right? And during the due diligence, there would be a lot of work with respect to researching the copyrights, patents, and certainly for both licensor and licensee, both parties would want to know about each other's reputation, financial dealings, the uniqueness of the products. So these apply to intellectual properties in general, and certainly not specific to life sciences. And let's take a look at the global intellectual property filing activities. These statistics come from the World Intellectual Property Organization. Global patent filings exceed 3 million in 2018, based on the latest data that we have. It's about a 5% growth. And China is really the main driver behind this. They account for 11% of the growth in patents, about 28% in trademarks, right? And what is astounding too is that China also accounts for almost half, 46% of the patent filings, and 51% in global trademark filings. So there's a tremendous amount of activities, and a lot of these filings in China or in other countries a significant percent of them are actually filed by non-resident filers. So companies outside of China, for example, filing for patents in China. And let's also take a look at the global IP filing activities around the world. The US actually had a decline last year, which is the first since 2009. So you can see in the trademarks area, there's a lot of growth across the globe. And this is what I was referring to. The orange bar here represents the non-resident filings, patent filings. So you can see that in the US, the non-resident filings actually exceeds that of the resident filings, right? The point here is that these patent applications across the world being filed in all the patent offices have global implications and therefore require language translations in many of these cases. Brian also touched on CEPHEUS, and the CEPHEUS, the legal requirements, and obviously trigger scrutiny, and the scrutiny would lead to either mandatory reporting or voluntary reporting. And again, because CEPHEUS specifically deals with foreign investments in these critical technology areas such as biotech, nanotechnology, etc., genetics, the translation of these compliance materials will be required. So that's another area where these international deals, whether it's a licensing or M&A, would trigger considerations for language and translations. So I think by this point, it's obvious that there is a language and a translation component when it comes to international intellectual property, international intellectual property filings. And COVID-19 obviously also has an impact, right? So as Brian alluded to earlier, it will have an impact on M&A activities, but the crisis is also fueling a race to find vaccines and treatments, obviously. And according to some recent research that we have done, there's some 160 plus vaccines in various stages of the development for COVID-19. And we went back a little bit further, and there were about over 700 plus distinct patent families for SARS during the 2002-2003 SARS outbreak. So I think it's reasonable to expect that given the size of this pandemic and the public health crisis that COVID-19 presents, that patent filings will probably trend in that direction. And case in point, a Canadian company, Predicmedics, just announced yesterday that they're filing for patent in the United States for mass screening. They're using some sort of imaging technology for mass screening. Okay, so this just came out yesterday. So what are some of the challenges when we're dealing with IP translations? This is a highly technical and highly specialized area, and a poor quality translation could potentially jeopardize the defense of the inventor's rights, right? So if there are issues or debate before a court, a poorly translated documents as part of the IP could affect your defense. And a translation that is not faithful or accurate to the original could also lead to potential suspension of the patent. So these obviously have significant legal and financial implications. And then there's, of course, the opportunity cost, right? An inexperienced translator could potentially add a lot of time and cost to what is already a lengthy patent filing process. And translation that is not delivered on time could also present serious challenges and damages to the overall process. So there are many translation companies that are basically do everything. They are the what we call the generalist, right? And we of course we understand that IP, intellectual property, is a very specialized field, and this is where a company like Montero brings that particular expertise. We actually have chemists and biologists and engineers on our staff as translators who know the particular verticals. And so they know the specific terminology as well as and in many cases, the legal framework in which the translation needs to be done. So with that, I want to thank you and thank the Westchester Biotech Project for inviting us and giving us the opportunity to speak today. So thank you. Back to you, Joanne.
Well,